Today we'll be covering the capital punishment cases of Gary Graham, Napoleon Beasley, Karla Faye Tucker, Sacco and Vanzetti, Governor George Ryan, as well as the subject of lethal injection.
On May 13, 1981 in Houston, Texas, Bobby Lambert was murdered during an attempted robbery in a Safeway supermarket parking lot. A 17-year-old by the name of Gary Graham was accused of committing the murder due to previous acts of violence. He was arrested 1 week after the crime took place. Graham, as well as 4 eyewitnesses who all underwent a polygraph test, claimed Graham was miles away from the Safeway when the murder occurred. Graham was arrested in possession of a .22 caliber pistol, which would later be proven not to be the murder weapon. In court, several eyewitnesses who claimed to see the murder were convinced it was not Graham. All witnesses claimed the killer was much shorter, and one witness who had seen his face protested he looked nothing like Graham. Graham had a court-appointed lawyer who, despite these testimonies, believed Graham was guilty and therefore did not investigate the case or make an effort to defend him. The jury convicted Graham based on the testimony of one witness, Bernadine Skillern, who insisted that she saw him through the windshield of her car that night. She testified that she saw the assailant's face for 2 to 3 seconds from a distance of 30 to 40 feet away. Graham received the death sentence, but his execution was delayed 5 times on appeal. The appeal for the new trial was denied based on a Texas rule that bars court review on any evidence of innocence brought forward more than 30 days after the trial conviction. Mr. Graham was executed in June 2000 after the Texas Board of Pardons and Paroles denied a final clemency petition. This case raises 2 important moral questions. Should juveniles, under 18 at the time the crime was committed, be sentenced to death? Should all inmates be promptly executed with no more appeals? We believe Gary Graham should not have been executed, as there was literally no evidence against him, and his court-appointed attorney made no efforts to prove his innocence. However, juveniles who commit malicious, inhumane acts with the intent to kill deserve the same punishment as an adult. We do not believe all inmates should be properly executed with no more appeals. In certain cases, like Graham's, more evidence is needed to convict the defendant, and the testimony of one witness is not enough.
On April 19, 1994, 3 friends ambushed John Luddig in his driveway in Tyler, Texas. It was supposed to be a carjacking, but in panic, one of the men, 17-year-old Napoleon Beasley, shot Mr. Luddig twice in the head, killing him as his wife crawled under the car. Beasley was found guilty and received the death sentence after the 2 co-defendants agreed to a plea bargain and testified against him. The 2 co-defendants escaped capital prosecution. John Luddig's father, Michael Luddig, was a very prominent federal judge, and he closely observed and participated in the case against Beasley. As a result of his involvement, the prosecution was able to dismiss a prospective black juror and seat an all-white jury. The case was taken to the Supreme Court. 3 of the justices disqualified themselves due to their close ties to Luddig, and of the remaining 6, a majority would have to be needed to execute Beasley. Because of Luddig's ties to the court, a 3-3 decision was a defeat for Beasley. Beasley was executed on May 28, 2002. In this case, we have 2 moral questions. Is it morally right to have an all-white jury for a black defendant? How can trials be fair if power and money are involved? We do not believe that it is morally right for a black defendant to face an all-white jury. Juries should be diverse in race, culture, and background in all cases. In many cases, trials that are tampered with using money and power are unfair to the defendant. The victim's father's involvement in Beasley's case swayed the Supreme Court, and while Beasley was guilty, he was not given a fair trial.
On June 13, 1983, Karla Faye Tucker used a pickaxe to kill 2 people who had annoyed her. The male victim, Jerry Lynn Dean, had once dripped motor oil all over her living room carpet and had cut up some photographs of Tucker's mother. The female victim, Deborah Thornton, just happened to be asleep beside Dean in his Houston apartment. Tucker didn't even know her. On a tape played at her trial, Tucker boasted that she felt a surge of sexual pleasure with every swing of the pickaxe. Tucker was found guilty and was sentenced to death by lethal injection. 14 years later, shortly before she was to be executed, Tucker launched an impressive last-minute campaign to have her sentence commuted to life imprisonment. She claimed that when she committed the crime, she was a drug-addicted prostitute, but now she was a born-again Christian who was sincerely repentant and reformed. She was an active evangelist, writing essays and making anti-drug videotapes, and she appeared on Pat Robertson's Christian cable TV show, The 700 Club. She managed to muster the support of a wide variety of character witnesses and sympathizers, including Pope John Paul II, the European Parliament, prison guards, former prosecutors, the detective who arrested her, one of the jurors on her case, and even the brother of the woman she murdered. Tucker's appeal was unsuccessful. The Texas Parole Board voted 16-0 against commuting her sentence. At 6:45 p.m. on February 3, 1998, Tucker was pronounced dead, 8 minutes after the injection of lethal drugs. Was it morally right to execute Tucker after her drastic change in behavior? We believe that Tucker still deserves the death penalty. She admitted in court to killing both victims, and her transformation does not make up for the lives lost. Even with her numerous supporters, we think her crime was so heinous that it deserves a fitting punishment.
On April 15, 1920, a paymaster for a shoe company in South Braintree, Massachusetts, and his guard were shot and killed by two men who escaped with more than $15,000. Witnesses thought the two men were Italians, and Nicola Sacco and Bartolomeo Vanzetti were arrested. Both men were anarchists and had evaded the army draft, and even though neither had a criminal record, they were immediately pinned as suspects. In July 1921, they were found guilty and sentenced to death. The conduct of the trial by Judge Webster Thayer was criticized, and indeed much of the evidence against them was later discredited, but the decision stuck. The court denied their appeal for a new trial. The Governor Alvin T. Fuller, after postponing the execution, allowed them to be executed on August 22, 1927. Both men owned firearms, and although Vanzetti's was never linked to the murders, Sacco's gun was tested years later using modern ballistics equipment, and is believed to be the gun that killed the guard. However, this technology was unavailable at the time of their conviction. Was it morally right to execute Sacco and Vanzetti based on little to no evidence? Similar to Graham's case, there was very little evidence to convict Sacco and Vanzetti for these murders. They were chosen as suspects based on their reputations and not on proof. Even though later reports claimed Sacco's gun was the murder weapon, that information was unavailable at the time of the murders. In the United States, the justice system claims you are innocent until proven guilty, and that was clearly not honored in this case.
George Ryan was the 39th governor of Illinois. On January 11, 2003, he announced the commutation of all Illinois' death sentences. In a speech delivered at Northwestern University of Law, Governor Ryan explained his reasons for ending the death sentence in Illinois. Capital punishment had been abolished in 12 states already. None of those states had an increased homicide rate. Nearly half of the 300 cases in Illinois had been reversed for a new trial or resentencing. 33 death row inmates were represented by attorneys who had later been disbarred or suspended. 35 of the black defendants had been convicted by all-white juries. 46 inmates were convicted on the basis of testimony from jailhouse informants. Most of those convicted are poor. Few people with money or prestige are convicted of capital crimes. Was Governor Ryan morally right? We believe it is up to each state to determine whether or not they use the death penalty as a form of punishment. Governor Ryan raised some excellent issues that are seen in several states, and an argument for both sides can always be made.
Lethal injection is used in 36 states having the death penalty. It has been adopted by these states in response to the objection that other methods of execution, such as gassing or electrocution, are extremely painful and thus violate the Eighth Amendment ban on cruel and unusual punishment. 3 drugs are used in the standard lethal injection procedure. The first is barbiturate, which is supposed to render the prisoner unconscious. The second is pancuronium bromide, which paralyzes the body while leaving the subject conscious but unable to cry out. The third is potassium chloride, which stops the heart and can cause severe pain as it goes through the veins. Critics of lethal injection bring up several problems with the method. One problem is that the paralytic chemical serves no purpose and does not always mask the pain. Another issue is that doctors refuse to assist in the lethal injection procedure because it violates their professional code of conduct. This results in the procedure not always being administered by an expert, which can cause complications. An extreme case where lethal injection went horribly wrong was with Angel Diaz. Diaz was a prisoner in Florida scheduled to be executed by lethal injection. It took him 34 minutes to die, gasping and grimacing with pain as the procedure stalled. A preliminary medical examiner's report found that the intravenous needles had not been properly placed in Mr. Diaz's arms. An autopsy revealed large chemical burns on his right and left arms. This case brings up 3 moral questions. Should doctors be required to do this procedure? Should special executioners be trained? And as currently practiced, does lethal injection violate the 8th Amendment or not? We do not believe doctors should be required to do these procedures. It is often against their personal moral and ethical beliefs, and the procedure is simple enough that it does not require a medical degree to perform. That being said, we do believe special executioners require training, so cases like Angel Diaz's do not occur. Lethal injection is the highest form of punishment, and it fits the most horrible of crimes, so we do not believe it violates the 8th Amendment. In most cases, the prisoner feels no pain, so we do not view this as cruel or unusual.
Today we covered the cases of Gary Graham, Napoleon Beasley, Karla Faye Tucker, Sacco and Vanzetti, Governor George Ryan, and the subject of lethal injection.